Please be ready for a dictation of part 2 from a write-up on high courts in India taken from jagranjosh.com. The material can be suitable for DDC skill and any other skill. 5 seconds. Start. Court of Record. It involves recording of judgments, proceedings and acts of high courts to be recorded for the perpetual memory. These records cannot be further questioned in any court. Based on this record, it has power to punish for the contempt of court either with simple imprisonment or with fine or both. Judicial review. This power of High Court includes the power to examine the constitutionality of legislative and executive orders of both central and state government. It is to be noted that the word judicial review is nowhere mentioned in our constitution, but the Article 13 and 226 explicitly provide High Court with this power. Extension of jurisdiction of High Court to Union territories. Parliament by law may extend the jurisdiction of a High Court to or exclude the jurisdiction of a High Court from any Union territory. Procedure for removal of judges. The Judges Inquiry Act governs the removal or impeachment of judges of High Court. Hence, the grounds for removal are proved misbehavior, incapacity. He is removed by the President as per the removal order passed by each House of the Parliament by a special majority, that is, a majority of the total membership of the House and a majority of not less than 2/3 of members present and voting. A detailed procedure followed is as follows. The initial removal motion to be signed by 100 members in Lok Sabha or by 50 members of Rajya Sabha and be presented to the Speaker, Chairman of the House. The Speaker has the option of either accepting or rejecting the motion. If it is accepted, a committee would be constituted to investigate the matter. The committee so constituted consists of Chief Justice or Judge of Supreme Court, Chief Justice of High Court, and a distinguished jurist. If the committee ascertains the guilty of the judge, then the houses take up the issue. If the motion is passed in each house of the Parliament by a special majority, then it is later presented to the President for his assent. The President then passes order for removal of judge. The judge is considered removed from that day. In fact, no judge has been removed till now. Transfer of a judge from one High Court to another. Article 222. According to it, the President may, after consultation with the Chief Justice of India, transfer a judge from one High Court to any High Court. Also, when a judge has been or is so transferred, he shall, during the period he serves after the commencement of the Constitution, act as a judge of the other High Court, so shall be entitled to receive, in addition to his salary, such compensatory allowance as may be determined by Parliament, by law, and until so determined, such compensatory allowance as the President may, by order, fix. Later on, in 1977, in K. Ashok Reddy case, ruled that there requires judicial review in case of arbitrary transfer of judges. Hence, as to locus standi, only the judge who is transferred can challenge it. Appointment of acting Chief Justice. Article 223. When the office of Chief Justice of a High Court is vacant, or when any such Chief Justice, by reason of absence or otherwise, unable to perform the duties of his office, the duties of the office shall be performed by such one of the other judges of the court as the President may appoint for the purpose. However, appointments of persons other than district judges to the judicial service of a state shall be made by the governor of the state in accordance with rules made by him after consultation with the State Public Service Commission and with the High Court exercising jurisdiction in relation to such state. Stop.